The Nevada Asset Protection Trust, NAPT. The Nevada Asset Protection Trust, NAPT, is a very strong asset protection strategy when properly set up as part of a well-organized structure of asset protection entities such as LLCs, revocable living trusts, and holding LLCs. This strategy works. Absolutes are unattainable. No asset protection strategy is absolutely effective, but this is one of the strongest. The only thing stronger are foreign asset protection trusts, FAPTs, in selective trust haven jurisdictions, such as Belize, formerly British Honduras, Cook Islands, formerly part of New Zealand, and Nievas. These FAPT structures cost a lot more to set up, usually $20,000 to $50,000, and have annual fees as well. For those with less than $1 million in assets, the NAPT is a more cost-effective way to protect your assets. This is Jim DeLoisio, Director of Legal Services of Torchlight Tax. In addition to doing taxes, we have a team of attorneys, paralegals, and support staff that work with our tax experts so that not only do we save our clients' tax dollars, but we also work to provide the appropriate gradient of asset protection based on their income, risk level, and net worth. See our short video, Gradients of Asset Protection versus Rising Legal Threats, on the Torchlight Tax YouTube channel. There are many other relevant videos on this YouTube channel and blog articles on our website. You are welcome to watch these and can contact us if you have any questions. The advantage the FAPTs have is they can ignore U.S. court orders. While NAPTs are not 100% immune to U.S. court orders, properly drafted and set up to take advantage of the extremely strong Nevada asset protection law, they are extremely difficult to penetrate. To explain this to you, I am going to go over some basics of trusts, including basic definitions. If you find this too difficult, you are welcome to contact us for a free consultation at 877-758-7797 or info@torchlighttax.com. Some people do not want to get involved in all the nomenclature and legalese and simply want the product of their assets being protected. They can simply contact my firm for a free consultation and stop watching. Others want to understand how it all works. If this is your wish, keep watching. 2 types of trusts. There are 2 major types of trusts, irrevocable and revocable. The revocable type of trust is the more common. When people say they have a trust, it is usually a revocable trust. These are great for avoiding probate court. See my videos on revocable trusts for more details on how revocable trusts work and how they avoid probate. These revocable living trusts are very effective in securing the transfer of your assets to your heirs and keeping the courts out of your family affairs. However, because they are revocable, they are ineffective at protecting your assets while you are still alive. Why? Because the court can order you to revoke them. Let's say your home is in a revocable trust, and someone wins a court settlement against you. We are assuming your insurance has already been taken, and that you do not have homestead protection in your state, or it has been used up. Homestead protection is a legal protection in some states that prevents your home or a portion of its equity from being taken in a lawsuit. You are in court and say you have no money to pay a judgment or creditor. You say all assets are in your trust. Your trust is revocable. The court says to revoke your trust, sell your assets, and pay your creditor. Now, an irrevocable trust is just that. You cannot just revoke it. The properties in the trust are owned by the trust, not you. A court cannot order you to revoke it because you cannot. Now, for some more trust basics. What is a trust? A trust is an agreement between the person who sets up the trust, called a truster, grantor, or settler, the person or persons who manage the trust, called trustee or trustees, and the persons who benefit from the trust, called beneficiaries. Now this trust is irrevocable, which means you cannot cancel it. Moreover, You can only make limited changes to it. This agreement is a private document. It is not recorded with the Secretary of State. The beauty of a Nevada Asset Protection Trust is that Nevada law allows you to protect your assets while still giving you a degree of control. First, you as trustor, grantor, or settler set up the trust and, in coordination with your advisors and lawyers, create the terms that you want based on Nevada law. You can also be the beneficiary of the trust. This is because Nevada law allows the settler, trustor, or grantor to be the beneficiary of the trust. That being said, there is a neat stratagem you can employ here. Make the beneficiary of the Irrevocable Nevada Asset Protection Trust, NAPT, a revocable living trust, and make yourself the beneficiary of this revocable living trust and anyone else you want as beneficiaries. You can later change beneficiaries as you wish in your revocable living trust. That way, you do not need to change your irrevocable trust in order to change your beneficiaries. The revocable living trust remains the beneficiary of your irrevocable trust. But if you want to take your ex-spouse or ungrateful son off as beneficiaries, you simply change the revocable trust. Okay, so you are the truster, grantor, and settler of your Nevada Irrevocable Living Trust, and your Revocable Living Trust is the beneficiary. Who is the trustee? Here is where you lock in your asset protection. There are 3 trustees. You are the investment trustee. This means you are responsible for all the trust investments. This can include rental properties, stocks, bonds, jewelry, your 1967 Mustang, or whatever. The investment trustee determines how assets within the trust are managed. Suppose you want to sell one of the rental properties that are in the trust. You, as the investment trustee, would tell the administrative trustee to sell the house and put the proceeds into the trust bank account. You could also direct the administrative trustee to purchase a different property, or stocks, or whatever. The administrative trustee is the one who signs documents in the name of the trust. Please note that none of the above are distributions from the trust. Nothing is coming to you personally here. The investment trustee is telling the administrative trustee how to manage the assets of the trust. The third trustee is the distribution trustee. This must be an independent person, that is independent from the person who created the trust, grantor, truster, or settler, and beneficiaries. Moreover, in an NAPT, the distribution trustee must be in Nevada. Now, no distribution can be made without the okay of the distribution trustee. This does not mean he has access to the assets himself. If you as truster want funds from the trust, you have to go to the distribution trustee and say, "I want $200,000 distributed to me for honeymoon in Paris." If the distribution trustee approves it, he tells the administrative trustee to give you the $200,000. Now you as grantor, truster, settler, can be the administrative trustee and investment trustee. But you do not have unilateral authority to withdraw assets from the trust. That authority belongs to the distribution trustee. In order to take an asset out of the trust and give it to a creditor or a winning plaintiff, the distribution trustee would have to authorize it. The distribution trustee is not going to authorize this. He cannot authorize this because the trust documents specified that only named beneficiaries can receive distributions. The truster would have to have distribution trustee authorization. What stops the distribution trustee from ripping you off? He cannot sign the assets over because only the administrative trustee can do that. How does this affect taxes? It does not in general. That is because this is a grantor trust, and the income flows through the trust to you personally for tax purposes. This means you personally must pay tax on the income you make. It is completely tax neutral. In certain circumstances, it can have some advantages for estate taxes, but this is something for another video. and is not its main purpose. So if someone tells you you can put all your money into a trust and not pay any taxes, don't believe it. Contact Torchlight Tax or another competent, trusted advisor. If you put your business into a trust, the business profits flow through the trust to you personally and do not create any tax issues. There are many ways to avoid taxes legally. Forming a trust is not one of them. See our blog articles and videos on strategic tax planning, cost segregation, accelerated depreciation, and many other tax-saving strategies on the Torchlight Tax website and YouTube channel. More advantages of Nevada Asset Protection Trusts. Nevada law gives specific advantages to NAPTs versus other DAPTs, Domestic Asset Protection Trusts. First, there is no statutory exemption for creditors. In some states, certain creditors can penetrate the trust. These are called statutory exemptions. Child support, alimony, and other things are statutory exemptions in other DAPT states, and thus these DAPTs are not as strong at protecting your assets as NAPTs. Another advantage of Nevada is that it has a short statute of limitations on fraudulent conveyance. Fraudulent conveyance is a civil offense, not criminal, and occurs when money is put into a trust to avoid a creditor. Let's say you have lost a lawsuit, are about to lose one, or are worried about losing one. You transfer all your assets into an irrevocable trust and say, "See, no assets." The court can penetrate your trust if they rule it is a fraudulent conveyance, also known as a fraudulent transfer. However, Nevada law puts a statute of limitations on a fraudulent transfer. If the property has been in the trust for 2 years, it is no longer a fraudulent transfer. Also, if you publish that you are putting an asset into a trust, then the statute of limitations is only 6 months. This 6 month or 2 years is sometimes called the seasoning period. Now, the NAPT still gives significant asset protection even during the seasoning period. But once the seasoning period is over, no longer is it a fraudulent conveyance. One other advantage of the NAPT is it allows you to take assets out of the trust and put them back in. Example, you have a rental property in the trust. You take it out of the trust to refinance it. You can then put it back into the trust. This does not restart the seasoning period. For these reasons, NAPTs are often regarded as the strongest DAPTs. Now, one of the interesting things about NAPTs is they are private documents. They are not filed with the Secretary of State like an LLC or corporation. All they are is an agreement between the trustor, grantor, settlor, the trustee or trustees, and beneficiaries. Creditors, lawyers, and other riffraff, just kidding, I couldn't resist, do not have access to it. Trusts do, however, have to be funded, i.e., property has to be deeded into the name of the trust. Another neat trick. There is another neat trick that can be used to maximize your control of the funds you put into the trust and to further confuse any would-be suing lawyers. Let's say you have a bunch of assets. You do not put them directly into the trust. You instead put them into an anonymous Wyoming LLC. Wyoming LLCs are anonymous because ownership data is not given to the Wyoming Secretary of State. See my video Asset Protection 2024. A proper setup of a Wyoming holding LLC, being the owner of an operating LLC in the state of operations, is strong asset protection. Let's say you have a few rental properties in Alabama, an operating business in Florida, and own some stocks and some other investments. Each of your rentals is put into an LLC that is owned by an anonymous LLC. Same with your operating business. By doing this, you get your assets out of your own name. You also make the owner of your stocks and other investments the Wyoming LLC. This is strong asset protection. The setting up of an irrevocable NAPT makes it extremely strong. Moreover, The NAPT does not require annual fees and simply puts another level of asset protection. It is a layered defense. This is analogous to a medieval fort, with a moat on the outside, an exterior wall, an inner wall, and a citadel. Each major defensive element has its own defense of archers, or hot tar, or whatever, just like each LLC or trust has its own carefully written operating agreement and trust document. What it looks like. This framework of asset protection has an exactly formulated structure. You have operating LLCs in states of operation. These are owned by an anonymous Wyoming holding LLC. The Wyoming LLC is owned 90% by an NAPT and 10% by the truster in their personal name. An NAPT is a self-settled trust created solely for the protection of one's assets from creditors. It is a strong way of protecting assets. The NAPT consists of a truster-settler-grantor, an investment trustee, an administrative trustee, a distribution trustee, and beneficiaries. An investment trustee is responsible for investing assets or funds of the trust according to his or her duties in the trust deed. A distribution trustee is a trustee responsible for distributing funds of the trust to the beneficiaries in accordance with the trust deed. It is important to note that a truster, settler, grantor should not be a distribution trustee, as this will expose his or her trust assets to creditors or lawsuits. Therefore, it is important to appoint a third party to be a distribution trustee. A lot of people are not comfortable with relinquishing control of their assets to a third party, justifiably so. But the NAPT allows the trustor, settler, grantor to still be in control of his or her assets. This is done by first creating a Nevada Asset Protection Trust with an investment trustee, an administrative trustee, a distribution trustee, and beneficiaries. The beneficiaries should be at least 2 for effective protection. Second, you create an LLC, usually an anonymous Wyoming LLC. The anonymous Wyoming LLC will be owned by the NAPT and the truster as well. The NAPT will hold 90% of the LLC, and the truster in his personal capacity will hold the remaining 10%. Third, the managing director of the LLC is the truster in his personal capacity. If John Doe is the truster, the managing director is John Doe. The trust document includes a clause that provides that the managing director of the LLC may make non-pro rata payments as he or she wishes, and that there are no mandatory distributions. This means that the truster, in his personal capacity as the manager of the LLC, may distribute funds to himself or herself or anywhere he wishes out of LLC profits, and fully control the management of the LLC and whatever profits he wishes to take from the LLC. The Wyoming LLC typically owns LLCs in the state of operation, including the truster's business, rental properties, assets, and other investments. Any major asset subject to any risk is put in its own LLC. Suppose you had 2 operating businesses and 3 rental properties, stocks, and bank accounts. The stocks and bank accounts could be put in the Wyoming LLC directly and out of your name. Each operating business and each rental would be in a separate LLC. By doing this, one bad rental or bad business could simply be closed, and no liability would be incurred for another business or rental. Thus, you have a structure, not owned in your name, that holds your assets. This Wyoming LLC and operating LLC structure is good asset protection, and many attorneys stop there. Having an irrevocable Nevada Asset Protection Trust, owning 90% of the Wyoming LLC, magnifies the asset protection. Suppose the trustor makes, say, $300,000 in a year from his operating rentals and business. He only owns 10%. Suppose he takes all $300,000 one year personally. This means he owes his irrevocable NAPT $270,000. So his Wyoming LLC is broke. and in debt to his trust. This is a good thing. The LLC owes so much to the Nevada Asset Protection Trust, it has no access to funds for a suing lawyer. And the irrevocable NAPT has all the protections of an irrevocable trust under Nevada law. The distribution trustee is enjoined from paying a creditor by the trust document created under Nevada law. Finally, the beneficiary of the trust is the revocable trust. Sound complicated to you? Imagine how it sounds to a plaintiff's attorney. Now, with enough millions in the trust, one might be able to find a way. That is why foreign asset protection trusts, being immune to U.S. court orders, are stronger. However, this is cheaper and adequately strong for up to $1 million in assets or so. Contact Torchlight Tax for more information or to set up a free consultation. You can also call us at 877-758-7797 or email us at info@torchlighttax.com. For more videos like this, be sure to like, share, and subscribe to our YouTube channel. Thanks for watching.